Exactly, and I decided to title this presentation Supporting Law Enforcement, a New Frontier. And I will show you why this is new, but not that new, because we've always been Sentinel. So first, what is the turn to sensing? I think I don't have to explain to you what is sensing, but I would like to ask you to focus not just on the use of sensors by ordinary people, like weather meters or noise pollution measurements, but rather really our human senses. Because if you think to humanity, we have always been sentinel. Basically, we have always been gathering data for our survival. But it's quite important to understand how this gathering of data evolved in history and also how the legal system evolved to kind of take into account these developments. Please confirm me also that you see something different, just because I don't see you, so I like to have some feedback. Oh, good. Yes, okay.
Yeah, we do.
Okay, fantastic. So here at the European Commission Joint Research Center, which is the basically scientific service of the European Commission, I lead the project called Sensing for Justice, funded by a Marie Curie Fellowship and earlier by the Dutch Research Council. I'm principal investigator, and this project is aimed to research the use of citizen-gathered data as a source of evidence to demonstrate environmental harms in court, so really in the judiciary, but also as a tool to avoid conflict escalation to the court and, for example, foster alternative dispute resolution. And I know Patricia is a pity she's not here with us because in the US, there is way more kind of familiarity with the potential of civic gathered evidence in litigation. Whereas in Europe, we are rather lagging behind. With a number of colleagues, we're also looking for avenues to recognize a new right under, let's say, the European framework for environmental information, that is the Aarhus Convention. We are pushing for a right of every person to contribute environmental information when the official information is kind of missing the full picture, struggling to offer good information to the citizens, to every person. Let me disentangle these points. First of all, what does it mean to use citizen-gathered data in court? It basically means to support law enforcement through gathering evidence on wrongdoings that maybe the authority or the industry is struggling to report, either for a voluntary wrongdoing or rather just for negligence. So I use this drawing where I basically depict a kind of a snap from a case study where a sentinel person gathering data shows to me a number of documentation that this person gathered to demonstrate pollution in his field that was also kind of poisoning his animals. The second point indeed is the idea that the evidence, the data gathered by the people can be used to go to institutions, to industry, to say, look, I have an informational asset and I would like you to listen and take action before I go to the court. And this is also a good strategy because tribunals and court rulings, proceedings, let's say, are very costly and they often do not offer a remediation for the environment that is, let's say, cost effective because lots of energy and money and time is taken in all the procedure. And the third point is indeed the recognition that the action of the sentinels, this is again a drawing from a case study in southern Italy, where the sentinels are actually at risk because the same act of monitoring can be seen as kind of revolutionary counter system. And so we also need a kind of legal rooting for why the gathering of data by ordinary people to demonstrate environmental issues is kind of legitimate. So we are clearly in a situation where we have complex issues to face. And then the question is the legal system taking, let's say, being able to be kind of on speed with these developments? And this is a sentinel who is saying to policymakers that basically their data are scientifically valid, but not only. They are also a legitimate response to what I define informational monopolies, which are basically situations where the information, in this case, environmental information, but could be also health information, for example, is kept in secrecy and is not duly shared with the actors that are entitled to know, according, for example, to the Aarhus Convention on access to environmental information, but also what, for example, in Italy, we call accesso civico generalizzato, which is basically the entitlement of every person to access information that the public administration is holding. So the idea is that there are turning points, and these are crises. And crises could be at several levels. I mean, we've seen now, sadly, the earthquake. We can think to the pandemic, we can see wars, we can think to environmental disasters. What crises have in common is that they kind of destabilize the system. And they also destabilized the kind of traditional delegation that citizens tend to do to delegate the monitoring responsibilities to appointed institutions. And what is particularly interesting is that institutions, including EU bodies, but also Environmental Protection Agency, national governments, local governments, should, in a way, get agile enough to adapt to this kind of fruitful innovation from below. And this can be seen as a form of kind of being open to collective intelligence, adaptation from below, creative resilience. But then the question is, how is the system coping with this? And I would like to offer you just a brief overview of how the monitoring of the environment by people has evolved through times. So as I told you, we've always been sentinels. So basically sensing the environment is nothing new. But then there are trends that kind of change the way we approach, we see the kind of the system. So more and more, we have been delegating the responsibility and the duty to monitor for us to appointed institution. But then there are changes such as the Industrial Revolution, where, for example, workers started gathering data on occupational and public health degradation as a counter system. So they started using data to kind of contest official measurement, official decisions, and so use data as informational assets to counter institutional data. At the same time, more and more scientific kind of institutions got recognized, and also citizens became kind of supporters as volunteers, as the Cornell Lab of Ornithology shows, that in a way kind of moved in a more, let's say, if we want, harmonious way with institutions. And there are other kind of moments of turning points, such as in early 2000, where basically the technological mapping and sensing potential of the people boosted incredibly. And also people that were not really into a need to monitor became monitoring people. So Then we come to present days, and I know this is not at all, I mean, unfortunately, the short time, there are all passages in between that are very important. But now we come to the present days, where crises are multiplying. There is also what we call science denialism, fake information. And so sensing in a way becomes more and more a way to protest, to contest. But at the same time, progress in, for example, AI showed a huge also platformization of civic monitoring that is maybe a bit less counter system. So we have local counter system forms of sensing and kind of organized networked forms of sensing. And in this maze, what I would like to highlight to you. So two trends. One is there, I noticed, and this is out of like now almost 4 or 5 years of research, a real trend of policy uptake of civic gathered evidence, which means that basically, even if at the start, the monitoring of the environment started as kind of counter system, over and over, the sentinels feel the need to kind of find reference in official signs, be represented in institutions. So they become first socially embraced, so they kind of spread across a critical mass, and the Safecast radiation monitoring example shows it. This was a case study for my thesis, my PhD thesis. But also interestingly, institutions, governments, local councils start understanding that the more the risk becomes high, the more the people become scientifically knowledgeable, the more also there is value in the initiative, even if the initiative initially showed distrust towards authorities. And I know this can be a bit complex, but I invite you to have a look to this book, which I published, and really shows the condition under which the policy uptake of citizen-gathered data is facilitated. It's a book, but if you reach me, I can also share the chapters in open access. More recently, with Sven Schade, Muki Hartley, and Mara Balestrini, we are studying scenarios where civic gathered evidence interplay with official data and official data platforms. This is quite interesting because it shows that there are a few examples where really the initiative is structurally embraced by the institution through a co-ownership of the data set, and that there is a legal provision recognizing this integration and also providing for a duty to consider this data. This article will be soon on citizen science theory in practice, so I point you there. And let's say, in the few minutes that are left, according to my time, yes, I have 5 minutes, I would like to kind of point your attention to what I call the judicial uptake of civic gathered evidence. And this is quite important because most of the people that I've encountered working on citizen science, especially in Europe, they rarely foresee the judicial potential of citizen science, civic gathered evidence, citizen sensing, whatever we want to call. I use often civic gathered evidence because they are broad enough, they don't scare lawyers, and they can be understandable by different audiences. So we started from a case in the US, and I was happy that also the first presentation mentioned fishers. Everything started from a motivated fisherwoman, which she gathered people around her. They gathered evidence to demonstrate plastic pollution violation of the US Clean Water Act in a Texas bay. And within this case, it's interesting because the evidence gathered by ordinary people demonstrate the harm without any contestation, nor by the judge, neither by the Environmental Protection Agency, the Texas Environmental Protection Agency, nor by the industry, Formosa Plastic Corporation, which shows basically that if the citizens are organized, if they can gather evidence in a way that is structured, also geolocated with a chain of custody of the evidence that makes sense, then they can reach the tribunal. And I'm facilitated in this interface because I'm an environmental lawyer myself, now being a researcher, but with a kind of a past as an environmental lawyer. And so I could interface both the civic sentinels, but also the lawyers of the case, and really analyze the condition that brought this very successful case. Sorry, I went too fast. So from there, we're looking for winning ingredients. So what would it take to have a similar initiative in Europe reach the court? And one study case, for example, is in Basilicata, where local sentinels in south of Italy are basically connecting geospatial satellite data with evidence gathered on the ground. So this kind of ground truthing approach, combining the two and using these as alerts for public prosecutors. So the evidence as such hasn't been used in court solely so far, but they have been used to alert public prosecutors into important environmental disaster proceedings. So this is quite interesting for us. That said, I would like to stress the fact that law can be a kind of a tool for the monitoring citizens, but can also be a barrier. Imagine the risk of trespassing, of legal charge, of defamation claims, and of strategic lawsuits against public participation, SLAPs, for the monitoring people. Think also to the personal health risks, which is why, and this is really based on my experience talking with the sentinels on the ground. I've visited, for example, Basilicata twice in the last years, shows why it is so important also legal recognition and awareness of this dark side of monitoring. And I would like to conclude, although I see that I really have 1 minute, not more, just passing through the fact that to reach our audiences, we are trying hard to go to the field, so really go where these people are, try to perform in a way scientifically based advocacies, for example, in the Aarhus Convention meeting of the parties. And lastly, we used emotional methods of scientific research elicitation in order to engage also those publics that are more difficult to reach. For example, youngsters, but also farmers, breeders, people that wouldn't never read a kind of a scientific article. This is why we are supported by illustrators. We made available illustrated consent forms to really ensure that our participants can understand what we are doing, especially because the legal, everyone probably in this presentation is with a high education level, but most of our participants are not. This is why it's very important to perform research also through engaged methods and storytelling. We are getting recognition. Last year, for example, the project got the award of the Science Engagement Breakthrough of the Year, exactly for opening the way to civic evidence of environmental harms. And we hope that this will continue in the coming years, as basically we need more lawyers, more judges, more sentinels that are aware of all these. So I thank you for your attention. And I hope I didn't, let's say, run too much and that it was clear enough.